Hey there, this is Matthew Jennings, and on this episode of Peachjar Extra Credit, I am here with F3 and a special guest, Gretchen Shipley, and we are going to be talking today about PRAs and FOIAs. What are they? What do they mean? What's your obligation in responding? So if you want to learn more on that, stick around. Gretchen, thank you so much for joining me here on this topic today. It is one that communications directors, superintendents, boards of education, anyone involved really at the administrative level in education is, they're always asking questions about FOIA, about CPRAs, about PRAs, how that process works, what are some of the ins and outs, what are some of the requirements. Can't thank you enough for joining me here today on this.
My pleasure. Thank you so much for having me.
Absolutely. Before we jump in, tell us a little bit about yourself, where we are. This is an awesome place. I've gotten the pleasure of working with F3 for many years in my previous school districts. It's fun to actually come to the office and see where you all live and you're not just a voice on the phone. Tell me a little bit about yourself and F3.
Sure. My name is Gretchen Shipley. I am a school law attorney, and F3 stands for Fagan, Friedman, and Fullfrost, but F3 Law is what we call ourselves, and we are an education law firm. We just represent school districts throughout the country, and my particular area of expertise, I chair our practice we call eMatters, which is specific to education technology, but we are a full-service education law firm, and Public Records Act requests and FOIA requests are something that we manage day in and day out. So I'm happy to speak with you and school district administrators and talk about how we can really manage that process.
That's awesome. I can vouch for that. I had the luxury of using F3 for years. My districts have partnered with F3 over the years, which is amazing. A lot of help on FOIA and PRAs over the years, and just a myriad of other topics, social media and photos, and we're going to talk about some of those in future videos. But I just can't say strongly enough how amazing your team is and you. So
thank you.
Let's dive right into this.
Let's do it.
PRA, FOIA, what is it? What does that mean?
Okay, well, first let's break down the acronyms. FOIA is the Freedom of Information Act, and that is the federal law that applies to record requests. And CPRA or PRA is California's. We are here in California, but people may be joining us from all over the country.
Yeah.
So California is the California Public Records Act. And they're very similar, and we can get into some of the nuances about how to manage them and what the requirements are. That's
excellent. Good. Yeah, so FOIA, kind of that federal level, PRA,
state level.
Little state level. In California, we're CPRAs. So you might hear me just mistakenly use those terms interchangeably, like PRA right. or CPRA, but that's kind of what I'm referring to. And so obviously, I'm sure you'll already do this, but preface this with make sure you're looking into your local laws, your local jurisdictions, right. working with your local legal teams, making sure that you're getting those rules and regulations correct for your area.
Absolutely. And they both have the same common themes. School districts are doing the public's business. Mm-hmm. Writings are the public records, and the public has a right to access them. And that is the basis for both of these. They're public transparency laws. And so requests come into school districts for copies of their records. When do you comply? How comply? What do you not? What is private? That's why you need sometimes as a lawyer, we get involved because there can be some really gray areas or some areas where school districts can get tripped up. That
makes a lot of sense. So let's talk about that a little bit. I did bring some questions because this is a hefty topic, and I want to make sure that I know that we got viewers out there that are asking a lot of these questions. I've had these questions over the years. I've worked with some other school districts that have had these questions over the years. So let's talk about what happens if a school district doesn't comply with a Records Act request.
Well, again, that's why I'm a lawyer and I deal with public records. So what happens if you don't comply? They are public records. They belong to the public. If you withhold them, someone can bring a legal challenge saying you are out of compliance. Mm-hmm. And you either get a court order requiring you to produce them, and you have to pay the other party's attorney's fees. So they're incentivized to try to maybe sometimes trip you up because they get their attorney's fees paid for. But the idea is it's a requirement. And I understand that school districts are buried in running student affairs and student matters and doing school district business. So how can we put some practices in place to make it more manageable and easier to respond?
That's great. And I should say, too, before we get into some of the questions that I have that are a little bit drilled down here, we are filming this it's May 2023. Things change, laws change, cases are always being heard. In fact, I have some questions that I think are going to lead to a couple of cases here in a little bit. But just know that at the time of this filming, May 2023, this is the best information we have in this moment. The CPRA process and the PRA process is actually decades old, right? It's a legal thing that's been around forever.
Yes.
And correct me if I'm wrong, but some of this was put into place before email, before records were just, I mean, we're creating records now at rates that just are unheard of back when some of these laws were put into effect.
Oh, for anybody, managing email is voluminous. And this absolutely, the law doesn't even specify in some places that we're talking about email. They think of records like a room, like a storeroom of actually
Folders,
printed documents.
Yeah.
So yes, compliance can be really challenging. On the flip side, email and computers allows for searchable terms. And so there has been process and procedures in place of how we can help work with the requester to agree upon some search terms, hoping that we find them whatever record it is that they are searching for.
Yeah, which is good. So that brings me to another question is, what if we don't understand what a requester is asking for? We don't want to just ignore it, as we've heard. We need to figure out what that really means. So what is our obligation then to help our requester through that process or help navigate our understanding so we know what we're getting to the records they're looking for?
That's a great question, because there are definitely strategies. First of all, the obligation is that you actually have to help them frame their request.
Okay.
If it doesn't make sense or they're not sure what they're looking for, a school district has an affirmative duty to help them even understand what they're asking for.
Okay.
So that's a bit of an unusual process. So we help them frame their request, and then sometimes they're still overbroad and vague. And what a tip is we offer to school districts is, can you get the requester to agree on what search terms they're looking for?
Yeah.
Can you, if they're not clear, maybe you can help craft the question for them in a way that's going to make it easy for the district to do their search.
That makes a lot of sense. I've had requests that get into the neighborhood of millions of records, relevant records are returned in the search results. So what happens if it's just an outrageously voluminous amount of information that you know is just going to take an exorbitant amount of staff time and resources? What do we do with that?
Few different things we can do. One is sometimes you can just object and saying it's overbroad.
Okay.
You can ask for more time because you don't have the staff and resources. You can push back on what is a reasonable timeline when they're asking for 100,000 records. Chances are they're not really looking for 1 million records. They don't have the resources to review 1 million records. So sometimes we get back to them after doing that initial search and say, just to let you know, this turned up 400,000 records. Do you want to clarify your request? And more often than not, they do.
Yeah.
And if it's truly they want all hundreds of thousands of records, then what is reasonable in the eyes of the law to dedicate staff time? And many school districts will take whatever time they need and are willing to defend that in a court of law. That if you're asking for 100,000 records, we don't have the resources to turn that around in 30 days. It may take 6 months.
Yeah. That makes a lot of sense. And can we talk about timeline, at least maybe in California? Like what is that obligation for responding?
So that is one of the easiest ways for a school district to get tripped up.
Okay.
Is a request comes in, we're all busy. Someone's record request usually is not our top priority.
Yeah.
And the law says in California, I think it's 10 days. For FOIA, I think it's 20 days.
Okay.
You have to at least let them know if you have responsive records. You don't have to produce them within the first 10 days. You just have to say, yes, we have responsive records. We will produce them. We will produce any non-privileged document within a reasonable time frame. And typically you would provide what that time frame is. What's reasonable? 30 days, maybe.
Yeah.
And it depends on the scope of
What
what you
that is.
find. But you say a reasonable time frame, that is where they can say you're not being compliant. You either didn't respond timely or you didn't follow through, and then they can come after you and say you're violating the Public Records Act. And I hate to say it, but we live in a day and age where sometimes people are looking to trip up a school district to say they're out of compliance, they're hiding something. And so it's really important. It's such an easy thing to do is simply just respond timely, at least on your initial request. The production can be a little bit more challenging to respond timely.
Yeah, redaction of records and such. So attend to those timelines. Can a district charge for records? That's one I get a lot.
So, and this can vary state to state. The general rule is you can charge for the copies. Like again, this law was written when they envisioned you putting a quarter or a dime into a copying machine. So you can, and now we don't charge per copy. So what is a reasonable rate to charge per copy? And you should tell them that in advance. This is going to cost you for every page. That's another strategy. If it's 100,000 documents, well, it's going to be a quarter per page. That might change your mind. But the thing you can't charge for, and which really costs a district, is people's time.
Yeah, the staff time.
Right. So that's not really a chargeable expense. I mean, the time to go through all of them and redact them and work with legal counsel in some cases to go through that process.
And the redaction, one of the things that I found really effective, let me know if you have other ways of doing this or if you also found this was a really effective method. I really liked the process of redacting documents in PDF format because there's an actual redaction tool in there that truly gets rid of the data. So is that something you found to be true or
Yes.
suggestion?
And that is one of the ways to manage either numerous PRA requests or voluminous or both. You know, some school districts have so many PRA requests come in, it's hard to keep track of them. So you mentioned one tool is redaction.
Yeah.
And we can talk about when you redact. But when you're going through and you are trying to protect private information, you can electronically redact them. And like you said, it gets rid of them. There's software.
Yeah.
We use software that we upload these records. It automatically can find when there's a duplicate, when there's, the concept of you have a whole email chain where they're bouncing back and forth.
Yeah.
And it really makes it so much more efficient to review the records and to electronically redact them and even upload them and produce them. So I know that's maybe an expense for a school district. It's a way where sometimes working with a legal team, it makes it more efficient, even though there's a cost of working with a legal team. So, but it's out there, and people should know that software management for record production is a tool that's available.
Can we talk a little bit about redactions then, and kind of what do you redact? What is on the table for that? How that works?
Yeah. So the general umbrella rule here is that this is the public's business, public records. What's a public record? It is a district record is maybe a student record, a personnel record, a financial record, a medical record, anything that a school district has to maintain. But a lot of that contains private privileged information. Yes. And so that's where a school district is in a really difficult position. And again, sometimes why we as lawyers get involved, because you're trying to, on one hand, protect people's privacy, because when you make it public, it's not technically just going to the requester. It is being made public. So you want to protect privacy. And on the other hand, it's the public's business and you have an obligation to provide it. So the way it works in our state, in California, I believe there are 78 different exemptions and for ground and privileges that apply when you can redact something. So a student name, that would get redacted. Sometimes, I'm trying to think, medical information, bank account information, attorney privilege communications. Yes. And then there's some that get real nuanced and detailed. But so that's where we go through and we say, okay, here's the body of records that need to be produced. Out of this body of record, or here's the body of records that are responsive. Okay. And out of what is responsive, what is then privileged and needs to either be pulled altogether or get redacted. We also recommend during that process keeping notes of why.
I was going to ask that.
Why you're pulling it, because let's say it gets challenged.
Yeah.
They're going to say, why did you pull that record? And you're
You can
6
cite
months,
that
you're down the
exemption.
road. Exactly.
Okay.
And that's another thing we do with the software, is in the software, we know what is the privilege that we're applying when we redact it.
Speaking of software, and there's probably software solutions out there. I wasn't privileged enough to have a sophisticated solution. I can talk about a couple that I had, but what are your suggestions for how school districts can track records requests?
And you are presuming the most important thing you just said is make sure you keep track of them.
Yeah, this is so true.
So, again, I understand, you understand. People running school districts are so busy.
So busy.
And the job of receiving, reviewing, responding to Public Records Act requests is different in almost every school district. Yeah. And so how to track it? The timelines is really important. We just create a spreadsheet, and anybody could create a spreadsheet. It is, what day did the request come in?
Yeah.
What is your timeline, your deadline to provide that initial response? What date did you provide that initial response? Mark what date you said you will produce records.
Okay.
Reasonable date. We said 30 days. So you mark that. And then some other columns come in if you do that process whereby you're clarifying what the request is. We're narrowing it. We're providing search terms. All of that should be put on a spreadsheet so it's really clear what they requested, what you agreed to provide, and by when, what day your response went out. All of that because you're juggling 20 or 30 of these at one time. It's
so true. I did have in one of my previous districts, we had a spreadsheet, and we did all of that, which is great to hear, like kind of confirmation that I had set that up the right way. And those search terms were invaluable, especially because I had to work so closely with our IT team on getting these responsive records. And so when something would come in and wanted all the emails from, say the superintendent to the board president, I would get those search terms from the initial request, get that in the document, then get with my IT guy. Hey, new request came in. Here's the date I have to respond by. I need to know if there are responsive records subject to these terms. And he had access to that document too. And then we had a little notes section there. We could go back and forth, and it gave me the dates. And then when I put that on there, it was kind of double duty. It was a little bit of a pain, but when I put a request on there, then I would go back on my calendar, my Outlook or Google Calendar, and I would make a note before the due date, before the 10 days was up, hey, you need a response to records request number, yada yada, and I would timestamp each one and give them a unique identifier. So that way in emails back and forth between myself and my IT director, I was also able to go back and search my emails for that exact identifier, and it would pull up all the emails back and forth, where we might be clarifying or he might be confused about what this term means, or maybe it resulted in 0, but we know there's a record out there. We need to go back and respond. And then in another district, we actually set up more of an official process for records requests. And when we would get them, if, say, somebody emailed me a request, I would, in the response, say, hey, in the future, we do have an official request system that you can use. If you want to continue to email me records requests, that's totally fine. But here's a system you might want to consider using. And then I had like 4 or 5 bullet points that just listed out the benefits. And one of those was it automatically tracked it for them, told them the responsive dates, and it was searchable for them so they could always come back to it. And it was a system that I worked with the IT team internally, and they built internal. And it was amazing. And then it would send me alerts, automated alerts to me, like, hey, you have 2 days to respond or whatever, which was really helpful for me. That system was amazing, and the district's still using that to this day. So all that being said, how can requests come in? Can they be scribbled on a cocktail napkin? Do they have to come in just via writing, certified mail? Can you set up an official process? What does that mean?
So first of all, your process reminds me of like Amazon tracking your package and taking a photo when it gets delivered. That sounds phenomenal.
So they used it.
Great. So how can they come in? Well, it's really broadly construed. Okay. All of these laws we're talking about, whether it's FOIA or the Public Records Act requests in California, they are all construed in favor of the requester. Okay. They are in place to promote transparency. So how can they come in? They're going to err on the side of, typically it is any written request for records is considered a Public Records Act request. So it is great if you have a system you can, if it's not clear, if it comes in on a cocktail napkin or on your email, on your district email, if you can direct them to what your process is. Hopefully 99% of the people will find your process and use it, and then 1% you direct them to it. Otherwise, it can be difficult to manage. Most of the time, requests for records would come into the district office to a designated person, but you need to establish that, preferably maybe on your website. That, and then train your individual school sites that if they're getting requests for records, they know to funnel them to the district office and the primary point of contact at the school district.
And that takes work off their desk. I have talked to a few districts over the years that are kind of scared to put the records request process on their website because they think it kind of opens up that people can do this. But I always err on, it makes it so much more efficient for everyone involved in the process, the requester, and on the other end, because then they're flowing through a process that you can more closely track and monitor because you've set it up. Have you found it to be true that districts that post this publicly online, here's our records request process, have been inundated with records requests because of that?
I feel like school districts are inundated regardless.
Yeah, okay.
And so the challenge is, my job as a lawyer is to reduce the likelihood of legal liability and help mitigate damages. And so I'm always, I don't want to encourage more requests. On the other hand, I don't want them to accidentally drop the ball and be held legally accountable and get sued over it because someone didn't follow through because they couldn't figure out your process. So, I suppose there's double-edged sword, but I think I would err on the side of having a process because these requests come in regardless.
It's true. That's been my experience, but that's good to hear. Just a couple more questions for you.
Okay.
So
bring it on.
What kind of records does a school district need to keep?
So this is challenging for most, let's say, staff members, but every school district, every state, every law has record keeping requirements, record retention requirements. There are permanent records. You have a student having a permanent record. There's some records that have to be maintained permanently. So you have a student record. You have a personnel record. Those are really obvious.
Okay.
What's really tricky and where a lot of people get confused is emails. And what do we do with all these emails? And is an email a record? And does every email have to be kept? So you want to know the answer?
Yes.
Okay. So it's not the form of the document, it's the substance.
There you go.
An email by itself is not necessarily a record that has to be maintained forever. School districts auto-purge email. They don't keep them all.
A teacher asking a teacher, you want to go to lunch on Tuesday at 4.
Right.
At 4 would be really late lunch. Bad example, but you know what I'm trying to say.
Exactly. Happy hour maybe.
Yeah.
So if an email an email certainly could concern a student discipline matter, or it could be evidence in a personnel case, then they are put into the student file. They're put in, so an email can become a permanent file that has to be maintained.
Yes.
But it, in and of itself, isn't. So most school districts will have protocols, policies, trainings to staff. When is it that you have to take an email and save it or forward it so that it can be maintained? Everything else isn't an official record. And some school districts choose to auto-purge at a certain interval. And there's no, at least in our state and federally, there's no magic number of how long a record needs to be kept. We think it's a good idea that it should be at least one school year because something can come up that you need to know. But the idea is a lot of school districts either want to auto-purge email at certain intervals after a certain period of time. There's a counter school of thought, which is we have endless cloud storage now. And some school districts are like, that's just another thing to manage is auto-purging of emails. We're not going to purge anything. And teachers, you go in and delete your own inbox every month if it's something you don't need.
Because I can imagine it'd be tricky to purge, but then still ensuring that you're capturing the emails that are records that need to be kept.
Right.
So, like, for example, a superintendent emailing an associate superintendent back and forth about an upcoming board meeting and the topics they'd like to see. Would that be a record?
If the district is still maintaining it at the time the request comes in.
Okay.
So I apologize. If it's when a district has to hang on to it. If a record request comes in and the district's in possession of it, it's responsive.
And it's responsive and needs to be disclosed.
It's when, as a school district, deleting or getting rid of records that must be maintained.
Okay.
So, but if you're still in possession of it, if it's still there, then it needs to be produced.
It's a responsive record.
Yeah.
And then, so should districts have probably public policy or administrative regulation governing if they're going to purge or whatever that is, like what that timeline is publicly?
And you have to have, there is a code of regulations that specifies when certain types of records have to be kept and for how long.
Okay.
And then on top of that, a school district should have an administrative regulation explaining, well, what do you do with everything else that doesn't fall into that category? And professional development's really helpful there. Okay, here's how long we're going to have you keep records. Here's how often. Here's when we want you to forward it, save it. Here's when you can delete it. And there's no black and white rule. Each school district needs to come up with their own best practice.
And I think staff training you touched on there is just critical. And I know that in my previous districts, I had the benefit of talking to like new incoming teachers, or we'd get together at the start of the year with all the administrators, and I would just talk about your emails are subject to PRAs. And some of your my last question here is on this topic, but that staff training component is really critical, and then that they know that everything that they put in writing could potentially become a disclosable public record. And so it's not to discourage doing the public's business on our district-sponsored platforms, but it is to say you need to know that if you're putting something in writing, maybe it's a particular topic that's disclosable to a records request, and you've been disparaging about a fellow staff member in there, that could be really embarrassing. So we want to be really intentional in how we use our district tools and conduct the public's business. That brings me to pretty much my last question. What about, so we talked about emails, we talked about some of the other records that we keep on file and hard copies. What about personal devices, text messages, my personal cell phone? Is that subject to records requests?
Yes. And just to jump back real quick, the catchphrase we use is pause before you post, which is something, speaks to both social media and emails. I mean, I just want to follow up on your comment about be thoughtful and mindful about what you're putting in writing. Sleep on it. If you're going to, controversial subjects come up, and sometimes you need to pause before you post. We have a training video on that very topic. If you want to check it out on f3law.com/privacy, it's a resource. It's a free resource to help people take a minute and think before I post something on social media, before I fire off an email. Pause, because there can be real consequences. And in this case, we're talking about it could be on the front page of the newspaper. So, not to say that people shouldn't communicate freely and do the district's business. You shouldn't hide anything, but by all means, sometimes it's a good idea just to take a beat. And then following up on your question about what if it's doing the district's business on a personal device or a personal account? So, at least here in California, we have, there was a court decision called the City of San Jose. We have a news flash on it if you want to check it out. It's, I think you're going to link it, but it is at f3law.com/newsflash. Okay. Every time a new case comes out, we publish the decision. And what City of San Jose said is, you can't avoid the Public Records Act by simply doing it via text message, personal email. If you're doing the district's business, it's the public's business, regardless of what account or device you're using. And so what happens is you can get requests not only for district email, but your text messages, your any other social media platform, any posts you might have. And then what happens is a school district has to turn to their employees and say, we won't go through your phone for you.
Search your device. Please
search your device. Here's what we're directing you to look for.
Okay.
You take the screenshots and send them to us, and then sign an affidavit that you complied and that's what you did. And I know that's a really uncomfortable process for a school board member or an administrator to have to do, but it's now what the law requires here in California, and I think it's pretty similar across the country.
It makes a lot of sense. Well, I appreciate that. I don't have anything else for you. Anything we didn't talk about that you want to add?
Here's some little inside baseball. Again, we've talked about how challenging this can be for people at a school district. And sometimes I get the question, do I really have to comply with this? We're talking about PRA requests generally, but there's different types of requesters. And different types of requesters, sometimes we do little cost benefit analysis of compliance. I mean, of course, I'm a lawyer, comply with the law. But you're going to get different types of requests. There is a concerned community member. Okay, they really are interested in knowing the district's business. You have the newspaper or the media. They're going to be very savvy on what your legal requirements are.
Yes.
They usually have lawyers on retainer.
Yeah.
So we take those very seriously. Another area which can really frustrate a school district is
I know where you're going.
marketing and business.
I knew where you were headed.
And they say, give us the name and address of every student or of every parent or of every teacher because we want to sell them something. Or I have had a request for, we want 12 years of every office supply you've purchased. And we did the overbroad type thing. But really what they're getting at, it's all marketing and business. So when a request goes out nationwide or statewide, some school districts do a little cost benefit analysis of how hard are they going to come down on me if I'm struggling with the timeline or I'm struggling to get the full scope of records. And so again, full disclaimer, conservative approach, always comply with every request. But they sometimes, when you don't have the resources to manage everyone the same, some are prioritized over others. That's what I said. It's inside baseball. It's more legal strategy there. But it's something that in the reality, day-to-day business of running a school, it's something they take into consideration.
That's huge. And, I can kind of relate to that on one level as a former PIO at school districts. When we would have an event that got national attention, your local media, your parents were always the one you focused on first. When I got calls from Al Jazeera and CNN and different things like that, it's like, well, you know what? You're here for the moment. But in 2 hours after you get my statement or story, you're never coming back. I'm never hearing from you again until the next thing happens, heaven forbid, right? And so it's really taking care of that local community with that vested interest and really making sure that you're meeting them in that space. I can't thank you enough for joining me here today. I know that this is a hot topic. It's always a packed room at one of the conferences, and I know you've been to the California, Kalispro conferences, and that's the last time you were at Kalispro, this past conference here in San Diego, it was a packed house. In fact, we had to put you in the biggest room. But it's like that across the state, and I've had the luxury of going to other state SPRAs conferences, and when there's a CPRA talk, standing room only in that room. So pretty clear that this is one of those hot topics that everybody just can't get enough on, and I really appreciate you taking the time to talk through me with this morning. So
well, I hope it was helpful.
I think so. I think we covered a lot of ground. I appreciate you taking my questions. We did talk about a couple of resources, and we will link to those into the description. So if you're looking for that, just scroll down to the bottom of this, and the description will have those links. If you found this helpful and useful, please like, share, comment, follow for more. If you have any questions, get in those comments. We were happy to participate in that space as well. Stick around. We got much more coming at you. In fact, I'm going to try to hit you up for a couple more videos. We'll talk about photos and taking pictures and things on campuses. We'll talk some social media stuff. So if you're interested, make sure you're staying tuned. That's all I got for now. We'll see you.
Thank you.